Okay, the subject today is wills. So what is a will? It is a declaration by an individual as to what he wishes to happen after his death. Wills are usually concerned with the disposal of a person's property, movable or immovable, wherever situated after his death. Formally speaking, a will can be defined as the legal declaration of the intention of the testator with regard to his property, which he desires to be carried on into effect after his death. Effectively, every person who is not a minor, is of a sound mind, free from undue influence, is capable of making a will. There are different types of wills. They include individual wills, joint wills, mutual wills, living wills, duplicate wills, and concurrent wills. Now, testacy and intestacy are important definitions, so we'll look at them carefully. First of all, testacy. When a person dies with a valid will, he is said to have died testate, and a grant of probate is granted by the court. Intestacy. Now, this is where someone has died without making a valid will. Note that the emphasis is on valid will. So he may have made a will, but later on it was held to be invalid. Now that would still count as intestacy. Laws of inheritance imply that where there is no will, then such laws must be used. For Hindus, Buddhists, Jains, Sikhs, the laws of inheritance have been codified in the Hindu Succession Act of 1956, while for Christians, the Indian Succession Act of 1925 is applicable. With regard to the form of a will or the format of a will, there is actually no prescribed format. However, in order to be effective, it needs to be properly signed and attested. It can be written in any language. No technical words are required, but any words used should be clear and unambiguous. No stamp duty is required in executing a will or a codicil, which is an addition or an amendment to a will. Note that a will must be attested by at least 2 witnesses. The other thing to bear in mind is that registration of a will is not compulsory in India. However, it is probably advisable so that there is some record of a will being held. Revocation and amendment. So let's look at those two. As far as revocation is concerned, a will can be revoked or altered any time during the lifetime of the testator. It can be made in writing. The will may be burnt or torn by the testator, and that would count as revocation, obviously. The will can be revoked expressly by another will or codicil, which, as I said, is an amendment or an addition to a will. On the marriage of a Parsi or a Christian testator, his will stands revoked automatically. But note that this is not necessarily the case for Hindus, Sikhs, Jains, and Buddhists. If there is a valid will, the executors have to apply for a grant of probate. The grant of probate gives the executors the legal authority to carry out the testator's instructions. In other words, what is set down in the will. A probate cannot be granted until the expiration of 7 days from the date of the testator's death. On the other hand, if there is no will, or if the will is invalid, a grant of letters of administration is issued. It's issued to an appropriate person, and that person is called the administrator. The letters of administration can be granted to any person entitled to the whole or any part of the estate of the deceased person. A point to remember is that the letters of administration cannot be granted until the expiry of 14 days from the death of the testators. With regard to Muslims, the provisions of the Indian Succession Act do not generally apply to a Muslim testator. Instead, the Muslim personal law applies. Under the Muslim personal law, a Muslim testator can make a will orally or in writing, and no form is required for such writing. Note that a Muslim can bequeath only 1/3 of his property by will. He can change his will during his lifetime or cancel any legacy. A will may also become void if a Muslim testator, after making the will, becomes unsound of mind and continues to do so until his death. Under certain circumstances, assets will fall outside the will. So let's look at these circumstances. First of all, consider an insurance policy which has been written under an absolute trust. Now, this asset would automatically fall outside a will, and there would be no need to put it through probate in the event of the death of the client. Another example would be where someone has used a nomination form in respect of the provident funds, in respect of his provident funds, because under the Provident Fund Act, the nominee will receive the money in the account without reference to a will. A third example where an asset falls outside a will would be where the asset is held under joint tenancy, in which case the survivor will be entitled to the asset without having to go through the will. So what are the contents of a will? Generally, will be made up of the following. There will be an opening clause, there will be a revocation clause, there will be appointment of executor or trustee clause, appointment of guardian, assets distribution, residuary clause, and an attestation clause. So finally, what are the benefits of making a will? Well, there are twofold. First of all, it's quite clear that the deceased estate will be distributed according to his wishes under a will. And secondly, the administration process is generally shorter with a grant of probate, so that the assets are distributed sooner. We'll stop there. The subject today is power of attorney. So what is a power of attorney? The definition of a power of attorney is that it is a legal instrument that is used to delegate legal authority to another. The person who signs the power of attorney is called the donor. The power of attorney gives legal authority to another person, which is called the attorney, to make certain decisions regarding property, financial, and other legal points. There are different types of power of attorney. First of all, there is the general power of attorney, which is that the attorney can carry out any transaction on the donor's behalf which the donor is legally able to delegate. Then there is the specific authority, which enables the attorney to deal only with those aspects of the donor's affairs which are specified in the powers. And thirdly, there is the general or specific power with restrictions and conditions, which, as it implies, authorizes the attorney to deal with all the donor's property and financial affairs except specified aspects. For example, the power may exclude the attorney the right to sell the house in which the donor lives. Now, so what are the duties of an attorney? The attorney is obliged to act in the best interest of the donor and to avoid any self-dealing. He is actually a fiduciary with strict standards of honesty and loyalty to the donor. He is required to safeguard the donor's property and keep it separate from his own personal property. Attorneys must also keep accurate financial records of their activities and provide complete and periodic accounting. The Powers of Attorney Act 1882 is the one which defined the various provisions of the powers available. The Act applies to the whole of India except the state of Jammu and Kashmir and came into force on the first day of May 1882. According to this Act, the power of attorney includes any instruments empowering a specified person to act for and in the name of the power executing it. With regard to stamp duty and registration, powers of attorney attracts stamp duty and need to be attested. A power of attorney which creates an interest in immovable property needs a registration. It is not necessary, however, to register a general power of attorney. But however, it is always advisable to hold a registered GPA while registering an immovable property in order to get better title to the property. Now, with regard to revocation, which is of course important, basically a power of attorney may be revoked by giving notice in writing of the donor's intentions and by keeping all relevant parties advised of the revocation. It is cancelled by the death of the donor or the bankruptcy of the donor, or if the donor becomes inflicted with unsoundness of mind. If the deed of power of attorney mentions that the power of attorney is executed after having received full value of a particular property and is irrevocable, then such power of attorney is called an irrevocable power of attorney. It cannot be revoked unilaterally. So those are the different powers of attorney, and that was the way in which such powers may be terminated. Thank you.